This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
And we are joined now by Todd Lutsky from the law firm of Cushing Dolan for Ask Todd. This is the segment where you get to call in and ask Todd your questions about your estate plan. So get on those phones. Studio line here is 888-205-2263. Again, that is 888-205-2263. We are now joined by Mr. Todd Lutsky. Todd, we need you to turn your mic so it's not pointing at me.
Oh, my mistake.
That being said, how are you? I felt that was rude to not say hi.
Well, thank you. I'm great. Thanks. Now that I know how to hold my mic.
I'm struggling a little bit personally.
Oh no, what's going on?
I got a new part-time job after work as a feather inspector.
Oh yeah,
I did. It's got me feeling a little down.
Yes, of course it does.
So, again, if you have a question for Todd Lutsky, the studio line here is 888-205-2263. So we'll open up the phone line so that you can ask Todd your questions about your estate plan. Mr. Lutsky, I want to start first with a question about vacation properties.
Sure.
Let's say that a family has a vacation property, and they want to continue to own it and eventually pass it down to their children.
Sure.
What are the optimal setups for being able to do that and take advantage of the greatest number of benefits possible?
So when you have rental property, it's a lot. There's, as you said, Chuck, there's a lot more to think about because rental property involves
not even rental, just a vacation home that they use themselves.
Oh, I'm sorry. So a vacation home. So even with a vacation home, which may or may not be rented, but if it's a vacation home, it's usually one where they're saying, you know what, I want this as a family memories. I want to get it down the road. And they'll say, you know what, I'll just put it in my kid's name now. Well, that's an option. Not a good one. But if they did that, you could end up with all kinds of problems from a tax perspective, from a control perspective, from a use perspective, right? So let's talk about the better way to do it, right? If I leave it in a trust, I wouldn't want to leave it outright to the kids, right? So if I want all of them to use it, I leave it in a trust, but I put language in there saying that those who want it can have it. The ones who don't want it don't have to have it, but the ones who want it have a right to buy out the interest of the ones who do. This is the first step so that it prevents people from who don't want it and won't care for it and won't pay the bills from letting it be run down. So that's number one. And it prevents fighting amongst the children. So now we got past the fighting part, and let's say they all want it. Okay, now it's in the trust for each of them. You then have language in there that talks about how their buckets have to maintain the property. So now I have some fiduciary obligations to make sure this property is maintained and not run down. And then the other problem you have with it, though, is, use, right? If it's going to be a vacation home and they all want to use it, you can leave it, an option would be to sort of let the kids work it out in terms of how they're going to use the property, who gets it on what vacation week or what holiday, vacation weekend or something. Or you can lay out a structure, in the trust and draft language about how and when they use it and how they alternate use of certain weekends. It depends on your family, but you need to think about that because that's all important. And that has nothing to do with taxes. Also, by doing your planning and holding it in the trust, you might be protecting it so that it actually gets to the family. If you just give it to them, not a great way to do it. You get a step up in basis when you die owning it to get capital gains tax treatment. So there's a tax benefit to dying owning it rather than giving it to them while you're living. You can shelter it for estate tax purposes. Folks, so many things to think about when you're dealing with real estate and how to fit it in there. Not just the probate and tax problems, but look at this one. It was all about use and family enjoyment, right? And things you don't think about when you're thinking about taxes and probate.
Speaking with Todd Lutsky from the law firm of Cushing Dolan, if you have a question for Todd about your estate plan, the studio line here is 888-205 2263. So get calling that number because we're going to take a quick break. But when we return, we're going right to your calls. So again, that studio number here is 888-205-2263. A quick break and then right to your calls right after this.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
Todd, we've got a call lined up for you. Let's go to Mark in Boston. You are on with Todd Lutsky.
Good morning, Todd.
Good morning.
I have a question on the life estate of my father.
Mm-hmm.
In 1990, he changed the deed on his 2.5 family house in Boston and put my sister's name on it and his name on it, plus a life estate.
So let's go slow. Let me go slow. So he transferred the property 50% to the sister, and he kept 50%, and he reserved a life estate.
Correct.
Got it. Go ahead.
Okay. And then in 2001, he passed away. And we just found out 2 months ago, my sister was retiring and selling the house, about my father keeping 50% in his name. We always thought the house had been given to my sister back in 1990.
Mm-hmm.
So now we've got a mess. And we're
Yes.
going to sell the house.
You do have a
There's
mess.
7 of us. There's 7 of us own his 50% of the house. And it had never gone to probate because at the time nobody knew that he had kept the 50% interest.
Yeah, that's a problem.
So now we're trying to figure out the basis. If she sells the house, how the life estate section of the deed would affect her basis and our basis, which I assume would be the date of death.
Yeah. So the problem you have, one, is you are gonna, if the property was owned, you have to answer this question: was that property 50% your sister, joint with your dad 50%, or was it tenant in common? I almost can't answer the question without knowing that answer, because that makes a huge difference. If it was joint, 50% sister, joint with right of survivorship dad, then when dad dies, sister automatically gets the property 100%, no probate. Now that's going to make everybody upset in your family, but you need to look at the deed and you need to find that answer. Do you know that answer for today?
Because they went to a lawyer to see about selling the house, and that's when they found out about the fact that my father still had his.
No. But do you know the answer about whether the deed says joint or tenants in common?
No.
No.
I saw the deed. It just said, I give to Helen Gaffey and John A. Gaffey,
Yeah, but if you're just, so the answer is you don't know, and that's okay, but you need to go look at it and see, because it says I give to my sister and joint ownership with him. You got to keep reading it. So if it's joint, then the issue is that it went 100% to your sister on the moment of death, no probate, no deed work needed to be prepared, and that's why nothing was done. And now your sister owns the property. Now, if it's tenants in common, then your sister owns half, and the other 50% is going to go according to his will. If his will says, I leave whatever I own equally to my kids, then each one of the kids are going to split 50%, okay? And your sister is going to be the owner of 50%. So your sister's at least a 50% owner, and you kids could be splitting the other 50%, including your sister, and then, or it could be 100% owned by your sister. But the deed will dictate that. So very good to see. And then lastly, the basis question. In this case, at least if 50% was left owned by him, even though he had a life estate, he arguably only had a life estate over what he owned. So if he only owned 50%, you're only going to get a half step up in basis on that property. So on the date of his death, there'll be a 50% step up in basis. I don't think you're going to be able to get the full step up because he did give away half. So that will help the basis a little bit. But again, he died in 2001. That property has significantly grown since 2001 to today. So I'm sure there's still going to be a large capital gain there. So thanks for the call. I sure hope that helped. But folks, this is exactly why we have to deal with real estate, how you own it and how to protect it, right? That's our guide. And you should call and get the guide, because this is really a disaster, right? You need to figure out the best way to leave assets to your family. And this, not to make fun, but this was not a good way to do it. It created creditor problems. It created tax problems that I see here. It's going to create ownership problems down the road for the family as they're running into now. Figure out the best way to have real estate fit into your estate plan and how to leave it so that you get creditor protection, tax benefits, control benefits, etc. Call and get the guide, Real Estate Ownership, how you should own it and how to protect it. 866-848-5699 or go to our website, legalexchangeshow.com. You can download it there. 866-848-5699 or legalexchangeshow.com.
Todd, I've got another call for you. Let's go to Cheryl in Grafton. You are on with Todd Lutsky.
Hi. I have a question regarding long-term care annuities.
Okay.
I have a relative who is 92 who was recently, went to a skilled nursing facility for long-term care.
Yep.
And I wanted some advice on whether that was a good idea to, I guess, protect some of their assets.
Okay. So the answer is when you have somebody going to a nursing home without any planning done in advance, or if planning was done in advance, there's still some assets that are outside of the trust and at risk for the nursing home, or I like to call countable when you're applying for Medicaid eligibility. So what do you do last minute is really the question here, folks. And this is for everybody. So if there's a bunch of assets sitting outside the trust and you have, in this case, a single person going into the nursing home, is there a way to protect or at least slow the financial bleeding of those assets because we want to get on Medicaid rather than pay privately? The answer is yes, there is. And in this case, an annuity might be one. Now, I don't know if I heard the age right. 92, if that was the age, then it might be a little high in terms of age to get an annuity. But if it was 82, because my fault in not hearing the age, but you probably have a better shot at using the annuity. What this means is that when you have excess assets over, in this case, if you're single, you can only have $2,000. You need to convert all the excess assets over $2,000 into an income stream. And it's that conversion by buying the annuity into an income stream that brings your assets down because it converts that to an income stream and you're left with like $2,000 in your bank account. One thing I want to stress, though, is it sounded like you might have already had an annuity. These are special Medicaid annuities. I'm not giving investment advice here. I'm simply telling you that these kinds of annuities have a lot of rules associated with them, and you need to seek out counsel before you buy this annuity. And if someone is telling you you already have the annuity, a Medicaid annuity, well before someone entered a nursing home, I can tell you that they don't. Okay, you cannot have a Medicaid annuity unless you're already headed in or in the nursing home because they don't exist. Other kinds of annuities do, but not that one. But this annuity is a great idea if that's your question. Buy the annuity, it converts the money into an income stream, and then you could become eligible for long-term care. But please follow the rules.
Mr. Lutsky, thank you for joining us today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated. This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. Evaluating how to smoothly pass along assets to your family is a huge part of a solid estate plan. Your home is most likely your primary asset, and if you think simply transferring it to your kids is the easiest way to go, you'd be taking a major risk, especially if they divorce in the future. Don't put yourself in an awkward position of having to buy back your own home just to protect it from creditors. Get Cushing & Dolan's brand new guide called Real Estate, Who Owns It and How It's Protected by calling 866-848-5699. There are better ways to own your real estate, and this guide will walk you through the process step by step, answer any questions you have, and put you in a more advantageous position to avoid probate down the road. Don't put your home at risk. Call today at 866-848-5699 and ask for your free guide, Real Estate, Who Owns It and How It's Protected. That's 866-848-5699, or you can request the guide online right now at LegalExchangeShow.com.